Hey Shannon, sorry everybody, I'm here. For some reason Zoom wanted to update.
The same thing happened to me too.
I have most inopportune times. Okay. Move things around here. Are you, Shannon, did you do introductions? Am I ready to start?
I haven't done introductions yet.
Okay, I will let you do that then. And I have one more slide to create, so.
Okay, one moment. Thank you for coming, everyone. Linda Sanders is going to be presenting on closing file protocol. But before she gets started, we do have the Institute CLE on Friday, December 1st. And we are still working on presenters and topics for it, but we should have the full program all set up by November 1st. So just keep an eye out in your emails for that link to sign up for. And that's also going to be a hybrid event, so you can attend via Zoom or in person. And I believe that's it.
We'll have a lunch and learn next month as well.
Yes.
And that is going to be it'll be very timely, on the procedure, so everybody knows and is aware you're self-reporting your CLE credits for this year. And we're going to go over what that procedure is going to look like so that everybody has an idea and is comfortable with the deadlines and where the forms are, what to do, what kind of supporting documentation you need, all of that kind of stuff. We'll answer all of that next month. I'm pretty excited about this procedure. We've been working hard on it, and it's really going to streamline it. And we're working with the state bar too, for some ideas moving forward to just make it easier on our members and on the committee as well. So
yes. And Julie, the CLE will be from 8:30 to 4:30. And Ariel, it will be hybrid. And the lunch and learn is just on Zoom for next month, and that will be the 15th of November.
okay. I'm probably missing one thing here. Okay, I am going to save this, minimize it, and start my screen share. Let me go to there. I've got things in the way. Sorry, I'm trying to figure out how to do this. There we go. There's my slideshow. And little pop-ups. Are you all seeing it as a slideshow now? Or do you see my side screens as well?
We see the side screens as well.
Huh, what am I doing wrong?
I think if you hit from the beginning.
Oh, there we go. Thank you. That would explain it. Okay, here we go. Hey, everybody. Thanks for your patience. As usual, I'm a little flustered. I just got out of another meeting. And so, okay. Notes. So today's topic is going to be, and Shannon, if I forget to move forward, remind me, please. We're going to talk about
Okay.
closing file protocols today. I am mostly going to be addressing physical files at the end of the presentation anyway, but a lot of the content is going to apply to those of you that do things entirely electronically. My area of law that I support, we simply can't be entirely electronic. When, in particular, protective proceedings, where you're still filing things in person at the courthouse. Right now, they let us email pleadings to be filed. Nothing is done through the e-filing system in protective proceedings. And therefore, as a result, you just have physical files. You have actual signed pleadings, etc. So, but those of you that can be entirely electronic, I wouldn't mind being in your world. So, I'm going to talk about the considerations about closing procedures. When is it appropriate to close a file? What does that procedure look like? And who is the person or people who are actually one, performing the actual physical scanning and things like that of the file, but two, more important is who's the oversight person to make sure that, and we'll talk about this later, but your case lists are current and correct. A much bigger job than the person who's just running things through a scanner to be saved electronically. Where's my mouse? There we go. Okay, so when is a file ready to be closed? Well, you know, we work in the legal field, and the answer is it depends. It depends on the area of law that you work in. For example, estate planning files, matters. Theoretically, once the documents are signed, you're done, right? You can close that file. We'll talk a little bit about what that looks like because it's not that straightforward. What happens, you have an estate planning client and the client wants to make changes to their estate plan 5 years down the road. Circumstances change, right? So yeah, you're done with the work, but you're really not, because that client routinely comes back for updates and changes. This is where it's recommended that you have an inactive status, and it is specific to estate planning clients, same with protective proceedings. You know, you're done. The guardian and conservator are in place. Your work is done depending on who you represent. But protective proceedings never go away until the person dies. So legally, again, circumstances change, things happen, you can be brought back into that matter. And so again, you don't want to close that matter. You want to move it to an inactive status. Other choice would be to withdraw as attorney of record for your client and let them move forward on a pro se status. It depends on the contentiousness of the matter. If it was a perfectly straightforward, everybody's on board, the whole family gets along, things are good kind of protective proceeding, then you probably can withdraw and let your client be pro se. But in my world, that rarely happens. Families don't get along. They don't agree what is in mom's best interest. And it is a contentious proceeding. And we don't typically recommend to our clients that we withdraw and leave them in the wind for themselves. So it, you know, attorney call, but it depends on what that looks like. Another example, personal injury cases. When are you ready to close the file? Theoretically, when you reach a settlement and the money's been distributed, right? Your client's done receiving treatment, and they're ready to get on and move forward. And theoretically, that file is ready to be closed, fully closed. Sometimes closing a matter is determined by statute. The easiest, the best example that I know about this is in probate proceedings. There are two ways you can close a probate proceeding. One is to petition for complete settlement of the estate, and that is a petition that asks the court to adjudicate the final settlement and distribution of the estate. The personal representative is actually discharged by the court from further demand or claims. A personal representative can petition to close an estate at any time after their appointment. An interested person or a devisee can petition to close the estate 1 year after the appointment of the personal representative. With the caveat that if the personal representative wants to close it, you have to allow for the time for claims to have run. So, and this is why people publish, right? If you publish your notice to creditors, there is a 4-month waiting period. No, 120-day waiting period for creditors to present claims. Once that time period runs, if the PR's done their job, they can petition to close the estate, wrap it up, done. As opposed to, again, if you are an interested person in the estate or a devisee, if a year has gone by since the personal representative was appointed and things are done, you can petition to close the estate. The second way to close a probate is you can do it by a sworn statement. You cannot close by a sworn statement before 6 months from the appointment of the personal representative. After the 6-month deadline, you can simply file your sworn statement to close the estate. But that even doesn't actually close the estate, because the statute says, and you guys can look at the probate code, chapter 45, the authority of the personal representative will not terminate for 1 year after the closing statement is filed. So beneficiaries or interested persons, if you didn't publish to creditors, this is why this 1 year. Creditors, if you don't publish, creditors have a year from the date of death to file claims. So filing the verified statement is why there's the 1 year after filing of that statement for the probate to actually be closed, and the personal representative no longer has authority to act. Other determining factors of when you can close a file, when it is appropriate. Statute of limitations is huge. I cannot understate the importance of knowing the statutes of limitations in your area of law. Predominantly chapter 7 is where we look at this. I'm not really going to address criminal law, more on the civil side of things. But in kind of rule of thumb for criminal law, though, is For felonies, statute of limitations is anywhere from 3 to 6 years, depending on the degree of the felony. Rule of thumb for misdemeanors is 1 to 2 years. So, basic rule of thumb for criminal statute of limitations. Civil side, they vary. Predominantly, most civil matters are a 4-year statute of limitations. Exceptions: medical malpractice and personal injury, a 3-year statute of limitations. Debt is interesting. If you're working in debt relief area of law, it depends on the type of debt. If it's a written contract, statute of limitations is 6 years. If it's the sale of personal property or an oral contract, those are both 4 years. So look at chapter 7 or 37, know what your statute of limitations are. When in doubt, ask your attorney. The big question about statute of limitations is, when does the clock start ticking? The rule of thumb is when the person affected knew or should have known that they suffered harm. So, for example, a child has a tonsillectomy at 11 years old. 10 years later, they're in a car accident. And as a result, x-rays are taken and they find there's a metal object lodged in their throat that is left over from the tonsillectomy. The statute of limitations starts to run on the day the metal object is discovered, not the date of the surgery when they were 11. So it's when they knew or should have known that they suffered harm. In this example, say the person in the accident had been having throat issues for a lot of years, but they didn't do anything about it, right? Failure to get their throat checked could bar a claim. So again, we work in the law. The answer is it depends. In terms of what we do, statute of limitations for legal malpractice is 4 years. In all of the above scenarios, you have to consider the time to file an appeal. So once you have your final judgment, what is the appeal timeline? Statute of limitations won't start running until the appeal timeline has run as well. So keep that in mind. Last factor of when is a file ready to be closed. Insurance, meaning your legal malpractice insurance. You have to know your policy. Some carriers require matters to be retained past the statute of limitations. So again, know your policy. Make sure your attorney knows your policy. Get that instruction and direction. It depends on how your firm is managed, whether your attorney will know that information or, if they're going to have to go to a managing partner or whatever that looks like. But that is absolutely a question that you need to ask when you're closing files. In particular, the rule relative to insurance that applies is Rule 16-104, and that's the communication rule. This rule says that an attorney has to keep a client reasonably informed and explain things so that the client can make an informed decision. That includes if you don't have the minimum malpractice insurance, and I forget what they are. It's $100,000 per incident, and I want to say 300,000 maximum is what the rules in New Mexico are. But if you don't have that, you have to disclose that to your client typically in the retainer agreement is where that is. If you work for an attorney that meets that criteria, they don't meet the minimum thresholds for malpractice insurance, your records relative to the communication that you disclosed that to your client, 6 years. So another, it depends factor, right? Know whether your attorney meets those criteria or not. Make sure it's in your fee agreement, and 6 years from the termination of the representation. That one's huge. I don't know many attorneys that don't have the coverage, but there are some. So next slide. How to close a file. And bear with me, I'm looking at why. Okay. How to close a file. So 14, 16, 12 is our statute that allows for electronic retention of files. So you don't have to keep a physical file. You just have to have it in electronic format. What that looks like is, one, it has to accurately reflect the information in the record. Okay, you have to have all the pleadings. You have to have all the discovery. Whatever that looks like, your file must be complete if you are doing electronic retention. Second, it has to remain accessible, which frankly, I don't know why they put that in there. What good is it if you can't access it? Is it really retained, right? The second rule that applies is 17204. And that says attorneys shall preserve records for 5 years after the final disposition or termination of the fiduciary relationship. So that's the state rule about retention. Again, it doesn't have anything to do with the other factors that we already talked about in terms of statute of limitations, or whether it should be just an inactive status, those kinds of issues. You must retain files, even if your statute of limitations was 3 years and you can close your file based on that. Rule 17204 says, no, you can't, 2 more years. So make sure your attorneys are aware of those rules as well. It's not just your insurance. It's not just statute of limitations. It's not just that you're done with the work. I love how there are always, it depends and except for and buts, right? So actual closing of your file. Why? Why is it important? Several reasons, right? One, consistency. You want to have protocols in place so that if you need to go back and look at something and pull something, it's easy to find. So if you have a written protocol, everything is done the same way, it's easy to find things. Plus, you know, we're all not going to be in our jobs for forever. Stuff happens. If you're the only person supporting your attorney who knows how to access stuff and what it should look like, what happens if you're not available. So you have to have that written protocol. In particular, single practitioners, it's a little bit easier, right? But what if you work in a big law firm? That protocol should be consistent across the law firm. It doesn't matter what area of law you practice. The closing file protocol is the same for the entire firm. And again, closing is status dependent. There are different levels of close, for lack of a better way to say it. So what does this look like? First, you should have a case list of all of your matters and their status. And when compiled for the entire firm, it's a huge document of all of the matters that the firm is currently working, right? Is it an active file? Is it an inactive file? Is it a file where the clock is running and you're just waiting for time to run out? Your spreadsheet should track that, right? Here's the date we finished the work. Here's the date that I moved it to inactive status. Or here's the deadline when all of your various deadlines to be able to actually close run. So when does your insurance say? That's a deadline. When does the statute of limitations run? That's a deadline. Are either of those past the 5-year deadline from the rule, etc.? That should all be tracked on your spreadsheet, and it should be constantly updated and kept current. This is the who piece, right? Who in your firm, in your practice, in your group of attorneys, who is the person that maintains that? It's a huge job to stay on top of that. Why? Well, one, we all have limited space. Bottom line is we need the room. We need to get files out when we can to make room for new files. Space is always a challenge. So you've got to keep that running list. We happen to keep a separate closed list that lists all of the details of the file being closed, when it was closed, when it was scanned, all of those different things. And the closed list also includes a tracking spreadsheet, so to speak. We keep our closed files electronically in a different place than we keep our active files. It depends on how your firm does things and what that looks like. But to keep a running list of the closed files so that, again, if you ever have to go back and look and see, in particular, conflict checks. Like I did a conflict check this morning where there was a name that popped up, and it was work that we did almost 10 years ago for a family member. I needed to go dig into that file to figure out whether or not this was going to be a conflict. So you've got to be able to track those closed files equally importantly. Let's break down the different levels of closed, right? The file status. We talked about the inactive files. The reason why I like putting things to inactive in particular is for billing purposes. My case management system allows me to put a file to inactive, and then I don't generate a bill for that matter every single month. It cuts my bills down hugely. I have a lot of files that are protective proceedings that I'm just kind of watching. They're not closed. You know, the person is still alive. They're still in my system, but I don't want to run a bill for them every single month and have to go through those. So one reason to have an inactive status. Second factor, sorry, bear with me. I'm going to move on. Inactive status. The other factor to consider when you're looking at this is, where do those files live? There is definitely a potential that you're going to need to get your hands on that file. I don't recommend an off-site storage for those files. You want them to be somewhere quickly. so that you can get your hands on them. Client's going to come back and want to make updates to their estate plan system, estate plan, or the protected person or your estate plan client dies, and you need to get your hands on what their documents say. What are the next steps? Who do you need to get documents to, etc.? What's the succession plan there? With your inactive files, the other reason why you want them to keep close is you do have to stay on top of them, right? You have to check them at least annually. Get on SOPA, find out if there's any new stuff going on, right? Are there new pleadings? Is there a new matter? Did your client die and you didn't know? Like, is there a probate now open for this client that you've been supporting? It does happen, right? So you have to check at least annually for any updates in the case. Estate planning clients, 3 to 5 years, you should check in with your client, touch base, say, hey, it's been a while since we've seen you. We're just letting you know, reminding you, you should review your estate plan. If your circumstances have changed, call us, let's make an appointment, talk about what the updates may need to look like. Our next level of closed, and I don't know what to call this, but basically time is running. You can't really close it. Your statute of limitations, your 5 years, your insurance, whatever the reason is, you are done working on this file, but you can't completely get rid of it yet, right? You need to calendar that deadline. That's, yes, you're running spreadsheet, but it is also in your case management system. However you do that, track the deadline for when you can really close that file. This is the point in your procedure, your protocol, where you really want to take the time to make sure that that file is organized properly. What does that look like? Your correspondence board, if you have that, is up to date, most recent on top, oldest on the bottom. Your plead board is up to date. Again, get on SOPA, make sure if anything is missing in your pleadings, put it on that plead board. Now is your chance. Because when you're ready to close and actually scan your file, be done with it, you're not going to rely on your summer intern or whoever is doing the actual scanning project in your office. They're not going to know to go online and look and make sure that everything is there. And you want everything to be there. Again, the rule says it has to accurately reflect the matter. Everything has to be there. Discovery, what does that look like? Yes, a discovery board that'll say who served what on whom, when you got the answers and all that kind of stuff. But in particular, where I'm going with this is, what does the actual production look like in your file? I have matters where I have 20 or 30 5-inch thick binders of documents. I have a document control index that tells me what's in all of those binders. It's all dated, it's all organized properly. If I ever have to go back and find something, my document control index allows me to very quickly put my hands on exactly what I want. But that has got to be up to date. And you've got to know how many binders you have, where they are, all of that kind of stuff. Other piece of information, original documents. What do you do with them? You come across death certificates or powers of attorney. letters of guardianship and conservatorship. Those documents are no longer effective, right? The person died. But they're original documents. What do you do with those? What does returning them to the client look like? What about original recorded deeds? There are a lot of circumstances that I can think of where you're going to come across original documents, and what the return of those documents or retention looks like for your firm. And then the other piece relative to these running files is, what does storage look like? The point being, regardless of what it looks like, if you have a great big file room and it's easy, they're either alphabetical or they're by your case number, however you keep track of your files in your office, or if they're off-site, Iron Mountain or something, they make it really easy. Like your box is labeled, right? It's got a QR code and a scan code right on the box. You keep a spreadsheet that says this file is in this box. Here's its number. If you got to get it back, you just send an email to Iron Mountain and they send you your box, right? That's super easy. What about if you have, your firm keeps and pays for its own warehouse, for lack of a better word, its own storage facility? What does the organization of that look like? You have to, again, have a spreadsheet that says, I put this file in room number 1 on bookcase D, shelf number 3, right? You have to know literally exactly where that file is, so that when it's time, when your time's done running, you can very quickly and easily send for that file to come back to actually be scanned and then destroyed. One of the factors to consider is the rule of thumb, so to speak. Never destroy what you cannot recreate, or what would be expensive or time consuming to recreate. When in doubt, keep it. In particular, discovery. Super important to not get rid of the discovery until your done is done is done. And here's where I ran out of time. Files that you're truly ready to close. All your statutes have run, all your timelines are run, you are really good to get rid of this file. What does that look like? 1, confirm. Check your deadlines. Make sure they're correct. Check with your attorney. Maybe there's some other reason, oh, no, I know we thought we were done, but you know what? The client called yesterday. They had a question about that. I'm glad you mentioned it. I actually need to look at that file, right? Just confirm that you truly are ready to close that file. Scanning the file, this should all be part of a written protocol as to what this looks like, step by step by step. Everything, when you're ready to scan a file, should be done in the same order, whatever that looks like. I do correspondence first. I do attorney notes second. I do pleadings third, discovery fourth, client documents fifth. It's in the same order every single time. Once it's scanned, it's bookmarked, and a new document index is created with those bookmarks, then scanned and placed at the front of the file. So really, correspondence isn't first. My scan index is what is on top. And it says anything and everything that is in that file and where that section starts. So again, if I need to go and find a pleading, I at least can narrow it down that, well, pleadings start at page 4,000. And I can go from there. I don't have to go through the first 4,000 pages to just get to pleadings. It's bookmarked, it's documented. What does scanning look like? Again, we keep our truly closed files scanned complete thing in a different place than we keep our active or inactive files. That is simply a computer storage issue for my firm, why we choose to do it that way. Pluses and minuses of that, but regardless, that has to be documented too, when and where it was saved to, whatever that looks like for your firm, for your attorney even. It should be consistent throughout. Know what your storage system is. Do you have cloud backup? Are you on the cloud, or do you have hard drives? If you're still on a hard drive system, what does that backup look like? Do you need to be keeping thumb drives or disks or whatever of your closed files so that if you need them, you can go and get them? Know what that cloud storage, whatever you want to call it, what that looks like. Super, super important. I have, and bear with me, I'm going to stop sharing this. So in terms of content, that is what I have, but I want to share, let me make sure here that I have it open. And I can provide these for you all. If anybody's interested, just email me and let me know, right? So this is what the closing file procedure looks like for the group of attorneys that I support right now. We use ProLaw as our case management system. And you can see how, and this is, by the way, this is like the truly closed, ready to get rid of and shred the file, which we, I assume everybody knows, like, shred your documents appropriately. I'll leave it at that, right? This is what that protocol is. This is not how we handle our inactive files, or our wait list, our running files. This is what it looks like to be ready to shred. A lot of firms don't actually move their files to closed status in their case management system. I honestly am not sure why not. Like, it seems to me, if you're doing a search, even if it's closed for conflict checks or whatever, it's going to find that information. If someone knows why it's preferred to not actually close, sorry, I lost, there we go, your files, I'd like to know, right? And as you can see, detailed, very, very detailed as to what this looks like. I'm trying to see if there's anything on here. Updating discovery. I don't know if you all do discovery, is the bane of my existence, but keeping a discovery board updated and complete is a huge task. Checks and balances is your certificate of service from your pleadings board. Our practice is, we also put the certificate of service on our discovery board. So it's in pleadings and it's in discovery. That way, if there's any ever question about what was produced when, it's in both places. That's more of an active file kind of thing. The binders of stuff, again, make sure your document index tracks with the actual binders, or with, if it's in your physical file. Make sure that you have everything accounted for and you're not missing Bates numbers 10,000 to 15,000. Like, where are they? Make sure what's on your shelf is what is on your index and that everything is there. You should talk to your attorneys. Different attorneys have different preferences overall and by case about working copies of pleadings or of documents, trust or the will or whatever kind of document they're working from, medical records, etc. They have preferences about retaining those working copies and what that they want that to look like. Accounting, invoices, fee agreements. Don't forget, those are a part of your client file. Yes, you have to. We save, our practice is every month when we bill an electronic. I have a folder in my active folder, my active case file electronically, where I save my invoice every single month from ProLaw into the electronic file, because it makes it so much easier when I'm ready to close my file. I have all of those invoices already there. I can simply compile them and add them to the great big huge scan. If you're not doing it that way, you have to do it now when you're really ready to close. So I simply advise doing it month by month. Same with any external invoices you get for copying services. You have a guardian ad litem that submitted an invoice. You have expert witnesses. Invoices can come from myriad of places, right? Those invoices are a part of your scanned file and they have to be in there. Just the point of F here, meaning be consistent on how you label things and what that looks like. Again, it goes back to simply being able to find things easily if you need to. Draft a closing letter to your clients and what that looks like. Is it when you're done with the work, but the run hasn't ended? Or is it both? You do a closing letter when the work is actually done, and you do a follow-up closing letter. Hey, FYI, the statute has run. You are truly off the hook. Now, your matter is completely behind you. Up to your attorney as to what that looks like. But again, make sure it's all there and gets a part of the file. Those closing letters should be on top because it's going to be your most recent of your correspondence, right? Put it all in shred bins, etc. Let the, again, I won't dwell on that, but dispose of your documents appropriately. Don't take them home and put them in your trash can. Don't put them in the trash can at your desk, etc. Do it appropriately. And I was trying to find, so I can share this document. The other document, whoops, did I go away? Yeah, oh, there we go. Okay. The other document I was gonna try and find, and I found it yesterday and I couldn't find it today, but let me try again. We actually, oh, I know where it is. Hold on. Because, bear with me, I opened it yesterday. Here we go. Let me open this and share it as well. This is our protocol for what our storage room, so to speak, looks like. So we have a separate building at our firm where we keep our running files. And this is what that protocol looks like. Again, it's super, super detailed as to what this looks like. But again, in particular, the point about all of this is to know exactly where that physical file is in your storage room. And we have a protocol. We keep a running list. That's this right here. Go to the last number on the spreadsheet so that you pick the right next number, what that looks like. We have a protocol for what it looks like to retrieve a file if you need to. That's part of all of this. Color-coded for different pieces, like the return slip that I was just talking about, highlighted to show what that looks like, etc. Then what are the steps if you need to reopen a file? God forbid it comes back from over in storage and you have to reopen it. What does that look like? What does then returning it for a second go round look like? All of that is a part of this protocol for our firm. This is exactly the same for our entire firm, regardless of attorney. All of our attorneys keep their running files in the same storage building, so to speak. So, and again, I can share this with anybody who is interested. If you guys don't have an actual written protocol like this, God forbid you're the only person who knows how your attorney likes things to be closed and what that system, much less what the tracking of it all looks like, you need to write it down like ASAP. And there, screen sharing is gone. So, I thought I maybe saw a question. Does anybody have any questions for me? There is a chat. Let me see. Yes, Christy, protective orders. That's an awesome example. Yes. Pay attention to your protective orders and when they end, when they have to be renewed, what destroying that looks like, all of that kind of stuff. That's a really, really great example. Super important, those protective orders and how you deal with them. And it looks like Shannon shared the JOT form for, don't forget, fill out your form, get credit for being here today. And someone earlier asked to share the link for so our next Lunch and Learn is going to be in November. And yes, we can send out that link. It's the same every single time. It just simply has the drop down and you can tell us what it is. The December CLE, I want to remind everybody. So this is what we call the Institute CLE. This is the CLE that we run in conjunction with the state bar. We do not do registration for that. You need to watch for that to come out through the state bar and register through them. Different than our Lunch and Learns or all of the other CLEs that we do actually. So watch for that link to come out. And one more plug. That same day is our December CLE, which is, I believe, Friday, December 2nd. That's going to be our holiday dinner. And Friday, December 1st. Sorry. That will be our holiday dinner. I submitted for the location. I'm waiting to hear from them to say, yep, we got you on the books, you're good to go. But that announcement will come out very, very soon as well. So that's all I have. Doesn't look like I have any other questions.